Welcome back. I'm Tiffany Meyer. The Supreme Court issued a series of rulings on Friday, including one that essentially limits federal judges' ability to block executive actions nationwide. Joining us to discuss are two guests, Alex Newman, award-winning international journalist and president at Liberty Sentinel Media, and Joshua Thompson, director of equality and opportunity litigation at Pacific Legal Foundation. Thank you both so much for joining us. Alex, first, how significant is this ruling limiting nationwide injunctions? What are you anticipating to see as a result from it?
Well, it's extremely significant. It's going to really rein in the ability of the judicial branch to get in the way of what Donald Trump is trying to do. But at the same time, it's a double-edged sword because at some point, Donald Trump is not going to be the president anymore, and these same restrictions are going to apply, presumably under a future president. So it's good news for Donald Trump, but it's also good news for whoever becomes president next.
And Joshua, your thoughts on all of this?
Yeah, maybe I'm a little bit contrarian, but I think it's going to have a lot less impact than people think. We have a situation where when individuals go to court and a court rules that some law is unconstitutional, that particular plaintiffs are going to be enjoined. That's what the decision says. But it's going to be somewhat foolhardy for administrations or other government officials to go and continue to enforce unconstitutional laws. So it remains to be seen. I think with in particular the executive order here with birthright citizenship, it's going to the court. There's going to be a decision at the Supreme Court. So what extent these nationwide injunction bans have, I don't really see it as significant as many people do.
Now, Alex, as you mentioned, this does mean that future presidents, including Democratic ones, will be shielded, if you will, as well from these nationwide injunctions. How could we see this play out in a future presidency when it comes to implementing more aggressive agendas?
Well, I think we saw during the previous administration with the mask mandates, it was one federal judge that was able to basically liberate America from the tyranny of the mask mandates with one judicial ruling. And those types of things, I think, will be on their way out. But in speaking to a number of legal experts on this issue since the ruling came down, one thing that's become very clear is that Congress is probably going to have to step in here and start defining some of these things. Because at this point, the judiciary is kind of just going whatever way it feels like. And there is a growing appetite in Congress to retake the reins of power, to reestablish the proper understanding of separation of powers. And the judicial branch, of course, is guided by the policies that Congress puts in place. If you read Article 3 of the U.S. Constitution, a lot of what the judicial branch is able to do and how it operates is going to be defined by Congress. And so I'm very certain that in the years ahead, Congress is going to step in and play a role in establishing what all this means.
Now, Joshua, besides that, too, the justices said that even without nationwide injunctions, plaintiffs can use class action lawsuits for a broader injunction. Walk us through that process.
The class action process is much more involved. There's a lot of steps. There are 4 factors that courts must consider to determine whether a particular plaintiff can join a class of plaintiffs. And some of the concurring opinions by the justices indicated that nationwide classes are going to be or ought to be difficult to come by. So it's just a procedure that is written into the federal rules. It's what the court says is the proper protocols for getting a large scope of plaintiffs' relief as you join them in a class. And there's opt-out provisions and a lot of protections for class members. But ultimately, the Supreme Court's opinion says is we want judicial opinions to bind the plaintiffs in the case. And when you have a class action, that is the mechanism for adding many plaintiffs to a case. So just go through the proper protocols, and you can essentially achieve the same sort of result. It's just a more intricate and court and the proper role for courts to bind non-plaintiffs cases.
Now, Joshua, staying with you, on birthright citizenship, the result was less clear given the 6-3 decision didn't offer a final ruling on the constitutionality of Trump's attempt at limiting birthright citizenship. Could we see this case go all the way up to the high court again?
Maybe not this case, but there are certainly other cases. I've also seen some talk that the plaintiffs in this case are trying to now form a class action. The Solicitor General in the oral argument for this case, when it was before the Supreme Court, indicated that if a lower court, if a circuit court is to rule against the executive order limiting birthright citizenship, that the Trump administration plans on seeking certiorari to the Supreme Court. So I think it's highly likely that this issue is going to come before the Supreme Court again, whether it's this case or one of the companion cases that are making its way through the federal circuits. I don't know.
Lot to watch for there for sure, Alex. In another case, though, the Supreme Court upheld a Texas law that requires age verification to access pornographic websites. Now, the petitioners had been arguing this infringes on First Amendment rights. Is this something you expect we'll see rolled out across the country?
We're already starting to see this more and more in Republican states. And I know there are civil liberties concerns about involving the fact that when you want to access these kinds of websites, now you're going to have to provide all sorts of personal data, which of course will be tracked, and we don't know who that data will be going to. But I think this actually opens up a broader issue in that we've gotten to a point now, which is what many of our founding fathers feared, especially Thomas Jefferson, where the Supreme Court seems to be kind of universally acknowledged as the final arbiter of everything. And that was never really the intention of our Constitution. Thomas Jefferson warned of a judicial oligarchy seizing power if we weren't careful. And it's at the point now where every time a state passes a law, every time Congress and the president pass a law, this goes to the Supreme Court, and then the Supreme Court tells us if this is acceptable or not. And it's gotten more and more extreme over the decades. I think we really need to have a broader conversation. And I think Congress is ready to have that conversation about to what extent are we going to allow the Supreme Court to govern us rather than the elected representatives of the American people, either at the state or the federal level.
Now, Josh, I'll let you answer that, but also did the court address the privacy concerns raised by the websites about requiring government-issued IDs for age verification?
The court was more concerned with the scope of how the age verification laws would impact adults' access to this pornographic material. In other words, that adults have a free speech right to access this, and the court was concerned of whether this law went too far in limiting the rights of adults to access the material. The court ultimately ruled it didn't, that the effect on adults' ability is incidental, since it's simply an age verification, not unlike bookstores of the past. And I think it is the court's proper role, maybe where I differ from my colleague, is I think it's the court's proper role to safeguard individual rights. That is the court's role in our constitutional structure. It ought to be here. And they said this Texas law did not violate individuals' rights to free speech, but it is the court's role to decide that question. That's what our courts are here to do.
Now, on that note, Alex, the Supreme Court also ruled that Maryland parents who have religious objections can pull their children from public school lessons using LGBTQ storybooks. Does this case expand what counts as a violation of religious freedom?
It seems to me, but it also, again, I think speaks to much broader issues, like the fact that the schools are doing this in the first place, the fact that government did not want to allow children or their families to opt children out of this. We're in a very strange place, I think, as a nation where we have government insisting on exposing children to LGBT propaganda, sexual material, and then having the government claim that parents don't have a right to do that. Very, very troubling to me. But it raises, again, when you go all the way back to the Supreme Court, it raises the same issue that I just described, in that it seems like we've gotten to a point now where the Supreme Court is the final arbiter on everything. And I don't think that's what our founding fathers intended. So I think obviously it's good that parents here have their right to opt their children out of this stuff respected by the court. But do we really need the Supreme Court to decide all of these major questions rather than the people's elected representatives? And I think that's really a discussion that this nation needs to have.
Now, Joshua, on that note, the ruling wasn't final, but the justices suggested the parents will win in the end. How are you viewing this case and the likely outcome here?
I think the Supreme Court's decision here does signal that I think it would be foolhardy again for the Montgomery County in this instance to go back and say, well, we think we're going to win on the merits, even though they are enjoined temporarily from doing this. I suspect the case will ultimately be resolved without further litigation. The Supreme Court indicated that what they were doing was unconstitutional by not allowing opt-out. And I think other school districts around the country will take note that when you are introducing material that offends individuals' religious liberties, that you have to give parents an opt-out provision. That's what has been the case with sex education in this country for decades. And the Supreme Court merely is extending that and recognizing that right when it comes to other sexually charged material outside of the sex education context.
And Joshua, your thoughts on the court rulings on the Affordable Care Act Task Force, the FCC Low Income and Rural Communities case, and why the High Court delayed ruling on Louisiana's redistricting map case?
Yeah, it's a lot to unpack there. I think after a series of victories recognizing the separation of powers over the last couple of years, of course, with Loper-Bright last year, ending Chevron deference. The court's decision on both the appointments clause and non-delegation were not those separation of powers victories that some of us in the liberty movement were looking for. I think the court has signaled that it is looking for different cases on the appointments clause and non-delegation before it's going to give any broader rulings on that respect. And with respect to Louisiana redistricting, I think the court, as was pretty clear during the oral argument, there's another Louisiana redistricting case coming up that challenges or questions the constitutionality of Section 2 of the Voting Rights Act itself. I think the court's punting on deciding this case this term indicates that it wants to hear those cases together and issue a broader ruling on the constitutionality of Section 2.
And Alex, your thoughts on the other rulings and what to expect when the High Court resumes in the fall?
Well, it's clear that the court has shifted a little bit to the right from where it was at even just a few years ago. And I think that's going to bode well for Donald Trump over the next few years. It's going to bode well for the Republican Congress over the next few years. But where we go from here, I think, is a little bit of an open matter. I think, again, we have seen quite a few encouraging rulings and encouraging developments. But I think there's a lot of frustration in Congress about the judiciary, broadly speaking. People have talked about the ability of single judges, rogue judges, small groups of judges to interfere with federal policy making. And I think we're going to see big changes. And I think even some of the members of the Supreme Court have started understanding that. One of the decisions issued by Amy Coney Barrett kind of alluded to this very issue, where we have the judicial branch, I think, usurping more power than has been delegated to it under the U.S. Constitution. So, good news for conservatives, for Trump. Some of it, obviously, a double-edged sword. But I think there are going to be changes in the years ahead. We've already seen Congress take some major moves. I think more are going to come down the pipeline in the future.
Major rulings for sure. Alex Newman, Joshua Thompson, thank you both so much for joining us.
Thank you
for having me.